I will start by expressing my gratitude to Professor Matirima and Dr. Mohamed Abbas for inviting me to contribute to the IP and Public Health Symposium at the Australian Centre for AIDS Law Research, Queensland University of Technology. Today, I will be talking on African regionalism and the use of the TRIPS flexibilities to promote access to medicines, particularly in the African continent. So, before the emergence of the agreement on trade-related aspect of intellectual property rights, which basically came with the establishment of the WTO in 1995, the major intellectual property conventions administered by the World Intellectual Property Organization, WIPO, were the Bonn Convention and the Paris Convention. Bonn Convention on Literary and Artistic Works, Paris Convention on Industrial Property Rights, covering trademarks, patents, designs. Under those earlier conventions, countries are only required to maintain a national treatment principle, which essentially means they cannot discriminate in how they afford protection to intellectual property rights owned by locals or citizens and foreigners. So countries were required to maintain uh, the same standard for both foreigners and their nationals. And there were different standards for IP protection under those earlier conventions. Uh, as long as there was no discrimination in how rights owned by foreigners and citizens uh, are protected, then countries were very much free to determine the level of protection offered for intellectual property rights uh, according to their national legislations or national laws. However, with the emergence of the TRIPS agreement, the agreement on trade related aspect of intellectual property rights, it became mandatory for all countries to have certain minimum standard for intellectual property protection. And that agreement substantially harmonized the standard for IP protection across the world. At the time the TRIPS agreement was being negotiated, fears were expressed by a number of parties to the WTO, especially developing countries and particularly India, that there was a real possibility of the provisions of the agreement impacting negatively on access to affordable medicines, especially in the developing world. However, the TRIPS agreement became part of the WTO package upon the completion of the Eureka Round for Trade uh, negotiations in 1993 thereabout, and essentially TRIPS agreement entered into force. Soon after the emergence of the WTO and the entry into force of both the WTO agreement and the TRIPS agreement, in 97, 98, there was a very serious HIV pandemic in South Africa. And in response to that, the South African government actually adopted or enacted a legislation empowering the government to use compulsory licensing and parallel importation to address the HIV pandemic in the country. So, compulsory license involves using the product that is protected by patent. I mean, in the patent case, compulsory licensing basically involves the use of the patented product without the authority or consent of the patent owner. Whereas exhaustion of rights basically means that once the patent owner has released the product protected by patent into the market, the IP rights, the patent rights embodied in the product have been exhausted for the purposes of sale and resale of the product. So, when the South African government made that law, allowing the government to use compulsory license and parallel importation to provide affordable medicines for HIV patients in South Africa, the Pharmaceutical Manufacturers Association took an action against the South African government. The United States government exerted very strong diplomatic pressure also on the South African government to withdraw that legislation. And what followed was a very strong response of support for the South African government from civil society organizations, from um, a lot of media commentators and academic uh, experts in the field as well. And the very strong global public outcry against the steps taken by the pharmaceutical industry in South Africa and the United States government led to the withdrawal of the action by the Pharmaceutical Manufacturers Association in South Africa. And there was also a clear statement from the United States government that the United States government would not intervene any further on legitimate measures being taken by developing countries to address the HIV crisis. Soon after the South African scenario, there was the 9/11 uh, terrorist attack against the United States. And after the 9/11 attacks against the World Trade Center, there were widespread reports of anthrax infested maize being circulated across the United States as a weapon of bioterrorism. And due to that very strong bioterrorism scare, the United States government decided to stockpile antibiotics for anthrax, and they went into negotiation with Bayer. Bayer was not ready to sell at a price the United States government considered agreeable, and the United States government threatened to use compulsory license should Bayer be unwilling to reduce their pricing. So this development actually brought to the fore the possible negative impact of pharmaceutical patents on access to medicines, and that led to the adoption of the Doha Declaration by the WTO ministers in November 2001. Essentially, the Doha Declaration reinforced the rights and power of member states of the WTO to take legitimate measures to address public health emergencies in their countries. And then there was a particular mandate from the Doha Declaration for the Council for TRIPS to find a solution to the problems countries without pharmaceutical manufacturing capacity might encounter in using the compulsory license system under the TRIPS agreement. Because under the original Article 31F of the TRIPS agreement, compulsory license could only be issued for, predominantly for use in the domestic market. And that basically meant countries without the capacity would not be able to use it because uh, if it's made under a compulsory license, it should generally not be exported outside the country of use. So what happened was the WTO uh, ministers in the Doha Declaration gave a clear mandate to the Council for TRIPS to find an expeditious solution to that problem. And that eventually led first to the adoption of the implementation decision in 2003, Doha implementation decision in 2003, and finally the protocol amending the TRIPS agreement in 2005. And with the protocol amending the TRIPS agreement, provisions were made for the use of compulsory license to meet demand of a country that may not have that capacity. So essentially, under the protocol amended the TRIPS agreement, it is possible to manufacture products, generic medicines for use in another country. However, there are a number of very rigorous conditions that must be met, including notification to the WTO, tracking requirement to ensure that goods made for a particular market are not diverted to other markets. So far, only one country has used the system, and that is Rwanda. Rwanda was able to use the system uh, through a pharmaceutical company in Canada that made HIV drugs for Rwanda in 2008. It is generally uh, believed by a lot of commentators, and that point has also been made by some member states of the WTO, that the system is very difficult to use. It is cumbersome and largely unworkable. And there is also the fear that countries that tend to use the system might come under the United States Section 301 watch list for violation of intellectual property rights. India, in particular, has actually condemned the system as very difficult and unworkable and has asked for more flexible standard. Nonetheless, I mean, the system is available under the protocol amended the TRIPS agreement. And a major provision of that protocol, which is now Article 31 bis of the TRIPS agreement, is that countries in a regional trade area with 50% of the regional trade agreement membership being countries in the United Nations list of least developed countries could use a compulsory license for the entire regional trade area. This is of particular importance to the African continent because in 2019, the African Continental Trade Agreement entered into force, bringing or creating an African Continental Trade Area. So, with the protocol amending the TRIPS agreement, it is very possible for African countries to issue under the African Trade Agreement or the African Trade Area a common compulsory license for the entire region because more than 50% of members of the African Continental Trade Agreement actually come under the United Nations list of least developed countries. So, more than 50% of members of the Continental Trade Agreement are least developed countries. And as a result of that, they are able to take effective use of that system. It is, however, to be noted that the system remains largely underutilized, and while there could be challenges with the use of the system, it is still a very viable option for making a more robust use of the TRIPS compulsory licensing regime and the parallel importation arrangement as well. Because what that means is also that once goods are released into the regional market, they can move freely without IP barriers within the market. A major challenge at the moment with doing that in the African continental trade area is the fact that even though the African Continental Trade Agreement has entered into force, not much has been done in actually giving full effect to the provisions of that agreement. And it is still correct to say that the trade area has not come into full force within the region. So these are uh, things that may have to be addressed for the regional arrangement under the protocol amended the TRIPS agreement, or Article 31 base of the TRIPS agreement, to be a very strong mechanism for promoting access to medicines in the African continent. But that provision exists, and it is one that I believe can go a long way in promoting access to more affordable medicines in the African region if that option is being effectively used. And thank you for your time and attention.